just to switch topics a little bit, I'm being told that Chauvin was sentenced to 245 months, and that's about 20 years in prison with supervised. Sorry? Did somebody say something?
Go ahead.
Okay, yeah, 20 years, I'm being told, approximately, supervised release for 5 years. So the defense lawyers won that argument, it appears, but that still means Derek Chauvin is going to be doing more time than on the state charges. What did you think about this sentence? Was it fair?
I think it's on the low end, but let's back up a little bit. Let's not forget, Derek Chauvin was originally willing to plead to federal charges, right? He wanted to serve his time in federal prison, but former Attorney General Bill Barr nixed the deal because it was only a 10-year deal. He didn't think it was enough. Of course, Bill Barr now is in the news still for other reasons. So there's no question that Derek Chauvin wants to serve federal time. That's why he pled in this case, even though he fought the state case and continues to fight it because, let's be honest, Derek Chauvin doesn't want to see some of his old friends in Minnesota State Prison.
Yeah, well, that's a good point. The federal prison is definitely going to be better for him, but it's still going to be tough. Alaleh, this sentence assures Chauvin is going to be in there for about, I would imagine, 18 and a half years now. And the prosecutors are probably celebrating, even on the state side, because even if an appeal was successful, this was a plea. I'm not sure if this plea was conditioned on getting through the appellate division in state court. In fact, I would doubt it was. So Derek Chauvin is got a significant sentence he's going to have to serve without the possibility of it having been reversed by this new sentence in federal court. What do you think about that?
Let's talk about also the fact that this was an 11C1C agreement.
Mm-hmm.
And so that your viewers understand, a C1C agreement, in a sense, ties the hand. It's an agreed upon disposition, and it ties the hands of the judge. And the agreed upon disposition was that Chauvin would do between 20 to 25 years. If the judge didn't want to go along with that, then the defendant would get to withdraw his plea. So I think the judge went with the lower end, stuck within the four corners of the plea agreement. And the plea agreement specifically asks Chauvin to give up his appellate rights, his motions rights, all of the rights that a defense attorney could raise in the future to try to set aside the plea or to get a reversal.
Yeah, in federal court, in NEMA, as far as that, giving up all of those rights, the only right I think they don't give up is to ineffective assistance of counsel, which is not going to work in this particular case. But that coveted, at least where I practice, the 11C1C plea is a very coveted plea because typically speaking, you go into a sentencing with an open sentence, probation department evaluating the guidelines, and depending on what the departures could be, it can be very difficult maybe to give your client an idea of what the sentence ultimately would be. But the 11C1C plea, if the judge accepts it, as is being discussed with Alaleh, basically limits the judge to that time frame. That's kind of a perk, at least from where I practice, to get an 11C1C plea. Did the feds, in your opinion, in this jurisdiction, give him that break so he had at least assurances it wouldn't be anything crazier than that?
It's a great deal for Derek Chauvin. I mean, let's be honest. Federal prosecutors rarely give 11C1C pleas. I can probably count on one hand the number of times I did it, and I put more than 1,000 people in federal prison. So, federal judges, district judges, they hate it. It ties their hands, and Alaleh talked about it. I mean, there's a big difference between state cases and federal cases. We talked about the percentage of time you have to serve depending on the state. In some states like California, you can ding or strike a judge. You can't do that in federal court. So you are stuck, and if you plead guilty, the judge can go above the guidelines. He or she can sentence you up to the stat max, and there's nothing you can do if you don't have one of these 11C1Cs, which are rarely given.
Yeah, so Alaleh, this is the kind of point where the case of this magnitude, knowing that he could appeal the state court sentence, when you're coming on that civil rights case, why would the prosecutors, in your mind, give this coveted 11C1C plea and limit it to the way they did? Because it would only guarantee Chauvin to get a couple of extra years should the judge, give the 20, but if they got the 25, a lot more. Is it just because they wanted to end this for the purposes of the community or what have you? Did they not want to try the case? Because it was a pretty slam dunk case for them on civil rights violations.
It is a pretty slam dunk case. And when you look at the base offense levels, the numbers can rack up there. But giving the defendant the C1C agreement, in this case, limited between 20 and 25 years, guaranteed that the government would get their pound of flesh, which is that the defendant would get between 20 and 25 years, and that the judge would not use 3553 departures, downward departures, and come below the 20 years. There's no way to read the judges. As you know, federal judges can come down or go above the guidelines. And in this case, the government ensured that the judge would not go below the 20 or above the 25, and that the defendant would not be appealing it.
Yeah, Nima, do you believe that maybe the prosecutors, the federal prosecutors, did this because they possibly were worried that if they didn't get the 11C1C guidelines with 20, 25 years, that there could have been downward departures that would have been less than 20 years in a case like this?
I think the real reason the feds did this is the Department of Justice's petit policy. And generally speaking, you don't see subsequent federal prosecutions after state charges are filed. There really has to be a compelling federal interest that isn't vindicated in the state case. Even though they're dual sovereigns, the state can prosecute, the federal government can prosecute. It rarely happens. We're seeing it with Derek Chauvin. Obviously, we saw it with Ahmaud Arbery's killers, the McMichaels and Roddy Bryan. But you don't see cases like this. It's perceived as piling on. And I think that's the reason, Bob, the feds did what they did here.
Yeah, interesting. Great analysis, guys. Okay, we're going to take a break. We're going to come back on the other end with more. We got a lot on the plate, like I said, so stay with us. We'll be right back.